I'm Alastair Hudson, and this is Equity and Trusts in Context. This is the introductory video. Now, I just want to try and explain to you what this course is about, and to give you some feeling for what the reading materials are about. And also, for some of you who might be new to trust law, you might be concerned about, will this course give me all of the basics I need in trust law? And the answer is yes, if you do it in the right way, and I'll explain all of that as we go along. Equity and Trusts in Context is about looking at equity and trust, which is a core course in universities in England and Wales, and putting that into context. So looking at the rules that you may have studied at a UK university on a trust law course, but putting them into slightly more context, going slightly more deeply into that law. And hopefully that will also serve as an introduction to those of you who are interested in trust law because you're coming from a different jurisdiction. This fits together with two other courses on this programme. There's International and Comparative Trust Law, which looks at how trust law in practice is used in the international context, on the international stage. There's also Commercial Trust Law, which looks specifically at how trust law is used in commercial practice. But this course is looking primarily at the English and Welsh rules, but not exclusively, a lot of Commonwealth comparisons as well, dealing with the creation, the operation of various kinds of trust. So this course divides into 4 sections. The first section is the constitution of express trusts. So that's how do we go about creating express trusts? Express trusts being trusts that a settlor has intentionally created in some way. Okay. The second section then looks at trusts implied by law. So that's when we look at situations in which the court has looked at the factual circumstance and decided that there should be a constructive trust or a resulting trust implied into that situation. We then look in the third section at liability for breach of trust, which isn't just the liability of trustees for breaching their trust, it's also the liability potentially of third parties who might interfere with the trust in some way. That could be anything from thieves at one end of the spectrum through to professional advisors perhaps who act negligently or even fraudulently in some occasions in relation to advising a trust how it's supposed to behave. Most interestingly, it might be professional advisors who are somehow reckless in, for example, the investment advice they give to a trust. And so in the recent financial crisis, there are bits of litigation starting to flow from there where people were advising investment in collateralized debt obligations and all of these complex securities that were bound up with that crisis, which ex post facto appear to have been reckless after the event. And so people are suing, saying, well, you encouraged me to do something which is a breach of trust because look at these enormous losses. So breach of trust covers all of those kind of contexts. It also covers the very important context of how do we recover property that was previously held on trust and which has been taken away and possibly sold, changed into other property, whatever it may be after the event. And then section D on this particular course looks specifically at trusts of land and trusts of the home. This is one of the most dynamic, one of the most litigated areas of law in this country, simply by number of reported cases at the minute. So there's the Trust of Land and Appointment of Trustees Act. The roots of trust law, of course, were always back in very important trusts over land historically. If you go back to all those Jane Austen novels, a lot of the Charles Dickens novels, many of those protagonists are struggling with the terms of trusts which hold them in poverty, for example, in Bleak House, or which in a lot of those Jane Austen novels mean those nice young ladies have to find wealthy husbands because when their fathers die, they're going to lose the house that they've grown up in. We bring it up, however, to the 21st century, very modern litigation, when there is a relationship breakdown or when a homeowner goes into insolvency, for example. How do we allocate ownership of that home between the various people that might be living there? And there are many different strands in the case law, all fascinating with that same kind of question. Many of these cases have involved unmarried couples separating and who owns the home. Others have involved married couples where one of them has gone into insolvency or failed to make mortgage repayments and the other spouse is saying, well, I have rights in this property too, you can't throw us out. So it's a very, very wide range, and those cases typically make the news when they're decided here, when they're decided by the Supreme Court and some of those higher courts, because it's recognised how sociologically important they are, because they govern so many millions of homes in this jurisdiction. So there's the recent Supreme Court decision in Jones and Kernet, for example, which has tried to regularise the law in this area, but has done so in a way that we might be thrown back on a general principle of fairness, which makes us start from scratch again. Because if you can't decide who owns the property in relation to the common intention test and so on and so forth, the court says, well, then you decide what's fair. Well, I mean, that opens up a whole door. And so that section D lets us ask lots of big philosophical questions about how should trust law treat this, as well as how does trust law do it. I love this area. I love equity and trusts, and that your main textbook for this course is my textbook, Equity and Trusts, which is in its 7th edition, if I remember rightly. Speaking now in 2013, there'll be future editions to come out. I bring out a new edition biannually at the minute. You don't need to worry about that because the study guides are updated annually. And also, I keep the structure of that textbook the same so that you'll always be sent to the right section numbers from your study guide. So you won't have to worry about, are you going to be sent, what pages do you need to read? You're always going to be sent to the right place. You also find that this course is supported by a large number of my podcasts, which are very short podcasts to explain in capsule form individual points of law. You also have all of my lectures available, all of my university lectures. So this is how, if you're new to trusts law and you haven't studied trust law before, but you're hoping that this degree programme will be able to get you into understanding trusts law, because there are many jurisdictions around the world now, of course, which are introducing trust law by statute. China, Thailand, Malta in comparatively recent years. Lots and lots of jurisdictions doing that. This is a good place for you to start learning your trust law from the beginning, because all of those lectures and all those podcasts are available to you. You'll also be provided with my short introductory textbook, Understanding Equity and Trust, which is only a couple of 100 pages long. It's a very easy read, and so if you're new to trust law, that will give you all the basics you need to know. The study guide, of course, will start you with everything we study in this course from zero, so you don't have to worry about having previous knowledge. If you have studied trust law before, for example, at a UK university or elsewhere, then you'll find that we'll very quickly move on from the basics that you'll have studied on undergraduate courses. We'll move much more deeply into Commonwealth comparisons, into some of the real practitioner debates in the background, and this course will move your knowledge and your understanding of this area of law far beyond where you were before. I personally find this an absolutely fascinating subject, which begins with Aristotelian ideas back from the Earl of Oxford's case in 1615 about the courts, through equity, intervening to ensure that men's consciences behave properly, up to the very modern context of how trust law is actually used in practice for tax avoidance, to manage assets, to organise ownership of the home. So it's a fascinating range of human endeavour, from Aristotle right the way through to the 21st century. And what this course aims to do is to let you find your own pathways, your own particular interests, through the material and through the readings.